National Review's Charles Cooke on why he says federal gun-free zones are unconstitutional, but not because of the Second Amendment. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also a CNN contributor and the founder of The Reload, where you can head over and sign up for our free newsletter today if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on hard news reporting and analysis. This week, we are going to be talking about the federal school gun-free zone law and a recent court ruling on it. To do that, we have one of my favorite writers out there, Charles Cooke from National Review. Welcome back to the show, Charles. Thanks so much for joining us.
Oh, it's a pleasure to be here. Thanks for having me on.
Absolutely. For anybody who may not have heard of you at this point, which I find surprising, you've been on the show a number of times, but why don't you give a little bit of the background of yourself?
Well, I moved to America in 2011. As you can hear, I wasn't born here. I dn't come from Kentucky and fake an accent for 14 years, which would have been quite the ruse. I live in Florida. Yeah, I live in Florida. And I've been writing on Second Amendment issues really since I arrived, both for National Review, also for the NRA. I write for the First Freedom magazine pretty much every month. And the reason I got into this was I became obsessed with American constitutional history when I was in college, and I wrote my thesis on the passage of the Second Amendment. And so once I arrived in America, all of the questions that arise in that area continue to interest me.
Yes, and so you have been focused on this as part of your writing since the very beginning, and you've continued to be. And I think you've covered a number of areas that don't get as much attention oftentimes, and you take a very analytical approach to the constitutional questions involved in a lot of our gun debate, right? And so, speaking of which, we had a ruling from, I believe it was the Second Circuit. Actually, it was the Fifth Circuit. My apologies. So it was the most conservative circuit that we have here in the States, or at least that's the reputation it usually gets. This is a 3-judge panel. It was unanimous, and they upheld restrictions on the possession of guns near schools. There's a federal law that bars gun possession within 1,000 feet of a school, and there was a defendant in Texas who challenged the constitutionality of this law after he was prosecuted for. It's actually quite an odd story, the background on this individual, but we can get into that in a little bit. But he claimed that the Federal Gun-Free School Zones Act is unconstitutional under the Second Amendment. The panel said, no, it's not. It comports with the historical tradition of barring guns in certain sensitive places, and therefore is constitutional. Now, you wrote a piece on this, and you actually said they got the law right here as far as the Second Amendment is concerned, but maybe not as far as the constitutionality of this law is concerned. Can you explain what you mean?
Yeah. So first off, let's separate out whether we think that law is a good law or not. I'm pretty skeptical as a political matter that it does much that is useful. The question that was before the Fifth Circuit was not that. The question was whether or not it was consistent with the Second Amendment.
Right.
Now, the Second Amendment, as the lower courts are entitled to interpret and uphold it, was most recently defined in Bruen 2 or 3 years ago. And Bruen requires that there be a historical analog in either the Revolutionary era or in the era in which the 14th Amendment was passed for a modern law to be deemed acceptable. And I think that the case is relatively strong here that those laws exist. And what you have with this federal law is a time and place restriction that is quite well cabined. And we've seen in New York, for example, since Bruen, that legislatures and executives that don't want the Second Amendment to exist are playing fast and loose with the idea of time and place restrictions, such that, in effect, New York City is a gun-free zone. That's not what time and place restrictions mean. But a time and place restriction that is, say, within 1,000 feet of a school is obviously limited. It's more akin to the rule that Secret Service imposes, where the president is. It's not the state the president's in or the country the president's in. It's the hall or the convention center or the White House. So that in and of itself meets the limited nature that Bruen requires. And then if you look back at the analogs, at the time of the founding, quite literally in some of the founding era state constitutions, some of which also contained the right to keep and bear arms, you will find restrictions on place, especially polling places at the time of the founding, were deemed to be legitimate gun-free zones. I can't remember if it was Delaware or Rhode Island, but one of those states had within its constitution that the people may not go armed to polling places. Only polling places and only when there was an election. So I think that if you're looking at this through the eyes of Bruen, which the lower courts are obliged to do, it's reasonable to say that there are historical analogs, irrespective of whether it's a good idea to have the law in the first place. My problem, and this isn't a criticism of the Fifth Circuit because this question wasn't posed to it. It wasn't accepted by them as an argument to be considered. But my problem is that the federal gun-free schools zones, doing what you did,
Gun-Free School Zone Act, yes.
Yeah, it's actually been through 2 iterations. In 1990, the initial law was passed by Congress and signed by the first President Bush. And it was challenged in 1995, taken all the way up to the Supreme Court, which struck it down. Now, it didn't strike it down on Second Amendment grounds. That would have been amazing, given that we hadn't even got to Heller yet. It struck it down on Commerce Clause grounds. Now, you'll forgive me a long answer here, but to explain how this works, for anyone who's not familiar, the American Constitution is really well conceived. The idea is that the federal government only has a handful of powers that it is allowed to exercise. When it exercises those powers, it is supreme. The Supremacy Clause makes it clear that it, rather than say the states or cities, is in charge. But it's only allowed to do the things that the Constitution grants it. Unlike the states, it doesn't have a generalized police power. Now, this gets confusing because although the Constitution passed in that form, immediately the anti-federalists said, we are worried that that won't be enough. We would like a Bill of Rights. I'm glad they did that, but it confused the logic of it because what you're doing there is you're saying the federal government's only allowed to do the things that it has been authorized to do, and it can't do this list of things. And that's why the 9th and 10th Amendment exist. They're really explanatory. What they're saying is we've added a Bill of Rights, but that doesn't change the structure of our enumerated powers. So the federal government can't do an enormous number of things. It only has a few powers. And what the court said in 1995 in a case called United States v. Lopez, for the first time since the New Deal, was the federal government doesn't have the power to pass this law. There's nothing in the Constitution that gives it the capacity to micromanage school districts inside the states. They're not federal schools, they're state schools. 5-4, it was struck down. So Congress takes this loss and it essentially copies and pastes the 1990 law into a new law in 1995, called the same thing, but it says this is legal under the Commerce Clause because now prosecutors have to make sure that anyone who's prosecuted is demonstrated in a court to have used or possessed or purchased a gun that was in interstate commerce. In other words, that had traveled across a state line at some point, or the parts of it had traveled across a state line at some point. And since that time, the Supreme Court and none of the lower courts have looked at this. And so, in a sense, Congress just said we've changed it slightly. But the objections that are in the original Supreme Court decision from 1995 are not met. The Supreme Court did not say in 1995, you need to add a line to this law. It said that structurally the federal government doesn't have this power. So my point here is the Fifth Circuit upheld this on Second Amendment grounds. I think that's probably the right decision. But I would like someone to bring, and a court to a higher court, because the lower courts have echoed the congressional change. I would like somebody to make a challenge on the grounds that the federal government simply doesn't possess this power in the first place. Because I actually think, Stephen, there are a lot of laws that are like that. For example, so-called universal background checks. I mean, there is a reason that the Brady Act applies to federal or interstate transfers, but not intrastate. That's up to the states. People describe that as a loophole, right? People who want universal background checks, they say it's crazy that in Florida, a Floridian can sell a gun to another Floridian privately over a kitchen table without a background check. Well, it's crazy if you haven't read the Constitution, which doesn't grant the federal government the capacity to decide how Floridians in the state of Florida, without ever moving outside or invoking federal law, should be regulated. So I think this is an area that is underexplored, and that's why I was annoyed by the decision. Not because I think they got it wrong, but just I wish someone would bring the secondary case.
Right. Yeah, and this that's one of the things that intrigued me about your piece is it kind of gets back to this almost like a meta critique that a lot of you'll see it a lot of conservative legal scholars have of the progressive era, the New Deal era, where the federal government's power was expanded quite a lot through this broad interpretation of the Commerce Clause, right? There's some famous cases from that period, right? Dealing with like farmers growing their own wheat, and the Supreme Court saying that the federal government can still regulate that activity because it affects interstate commerce, right? This has been a long running, fight back and forth between, the conservative wing of the legal sphere and the progressive one, right? And and so it's interesting to see how this law fits into that in your view, and it gets at this question of federal power, right? And how far it ought to extend. And so in this case, you're saying. Now, obviously the counter argument here is this guy, the specific details, besides the Second Amendment case, which you said, is perhaps justified under the sensitive places that existed at the founding. I think this court pointed as well to affray laws or going armed laws because of the details of the specific defendant.
Yeah, you see, I just want to, I'm a little skeptical of that argument. That argument was raised in Bruen in the dissents as well. The affray laws were there to prevent people from using guns to terrorize others. And I think that obviously that should be illegal. And if there are laws that make that illegal, they're presumptively constitutional. But if I conceal carry near my children's school, I don't think that's analogous to an affray. So I'm not suggesting you do, but I think this affray argument gets made far too liberally for my tastes.
Yeah, I mean, in this case, because the common objection to this law that you'll hear from people is more about, people who have concealed carry licenses, that are vetted should be able to carry at schools, or if they go to pick up their kids, or there should be, accommodations for that is all the common critique you'll hear outside of the, constitutional challenges that you'll also come across. But, in this case, I guess there's the specific facts of it, right? This is a guy who started in New York. He drove down to Pennsylvania where he bought an AR-15, and then he drove down further to Texas where he kind of just camped out near this private Catholic school for weeks, apparently, and was sort of a nuisance, I guess, or at least was unnerving to the parents. Now parents can be unnerved fairly easily sometimes. But in this case, they claim this guy made some comments that people found threatening. He refused to move his car from near the school, and then when they arrested him and searched his car, they found writings they found videos of him torturing animals and things of that nature. And so the court is saying, he was like, I guess his presence was threatening to these people, and that's how they analogize to. Rather, it's a bit of a different, I guess, situation than somebody who has a license carrying near a school. But
well, it is. But the fact that he was probably a terrible person doesn't change the enumerated powers argument or the analogy. And it's worth saying that an awful lot of states, I don't know the exact list, but an awful lot of states have state-level restrictions on carrying firearms near schools. Mm-hmm. A lot of red states that are otherwise very good on guns have those laws. So he probably broke a whole bunch of state laws here as well. And he probably would have broken a bunch of state laws if he was threatening people. I mean, it's illegal to threaten people. That's not protected speech. So I'm always a little skeptical when that line comes up. But yeah, he was a bad dude. It's very often the case in questions that deal with the Bill of Rights that the person who has been brought before the court is awful. I mean, this was one of the political, not the legal, but this was one of the political problems with Rahimi. You end up looking as if you're defending a guy who was terrible. But if you go back to the period in the mid-20th century in which the Warren Court decided all manner of rights existed in the Constitution that old school liberals absolutely love, the people involved in those cases were rapists and child molesters and serial killers. Sure. It doesn't change the fact, right? So this is an issue we always have in the gun rights movement, is that very often when there's a court case, the person who is the plaintiff in the case is extremely unsympathetic, and we would loathe that person, and we think they're irresponsible and terrible and should be in prison. But, the issues are still the issues. Yeah,
and the core critique here is more, from your point of view, more on the power of the federal government to do something like this. And so, obviously, the part of that whole chain of events involves him being from New York, going to Pennsylvania to buy the gun, and then ending up in Texas with it, which is how, I guess, somebody defending the current law would justify, this is where Congress can get involved because this is an interstate event. But what do you think of that?
Well, I just don't buy the logical chain there. I mean, let's think about something else unpleasant for a moment. Let's assume that somebody drove between 10 states, contiguous states, and in each one, they had sexual relations with somebody who was 17. Right? So in some states, that's illegal. And in some states, that's not. Some states have different age of consent than others. The fact that they implicated 10 different state laws in the course of that journey does not give the federal government the power to pass a national age of consent. Or you don't even have to be as provocative as that. You can just talk about drinking. I mean, prior to the 1980s, the states set the drinking laws. Some were 18, some were 21. And so it was absolutely possible, especially if you lived on the border, to go for an evening, if you were 19 years old, out of your state in which the drinking age was 21 and into the neighboring state where it was 18. That was legal. It's illegal now to do that with drugs. If you live in a state that has decriminalized marijuana, somebody else from the neighboring state can come in and legally smoke a joint with you. I think the question is, well, does that give the federal government the intrinsic right to pass laws that regulate either of those things? And I just think the answer is no. So I understand the argument being made, and I think probably under contemporary Commerce Clause doctrine, a lot of courts would uphold it. I don't think it's consistent with originalist constitutional thinking.
Right. So from your view, this law is not and I think this is a fair point. They didn't really address the actual underlying issue from that Supreme Court case. They just added a interstate commerce justification to it in the text of the law as it stands now.
Well, it's also it's just such a difficult political thing to be against. Right? I mean, if you look back to the mid 1990s, where you had a law and order majority. The 1994 Republican Revolution was driven by crime as much as anything. And you have a law called, I always get it wrong, but effectively the Keep Children Safe at School from People Who Have Guns Act, right? and you challenge it once and the Supreme Court strikes it down. Do you want to be the guy who immediately takes it back? I mean, it's just the incentives are all wrong. So tough.
Yeah, and you're going to likely end up with a fairly unsympathetic plaintiff like this guy, as you mentioned.
Right.
Not that should impact how the case turns out, but it likely impacts the public perception of it, certainly.
Definitely.
But, in the end here, you're saying, this law, and I imagine quite a number of other federal laws that use a similar justification, ought to be unconstitutional, ought to be found unconstitutional because this interpretation of the Commerce Clause is sort of undermines the very nature of the constitutional order. But at the end of the day, you also don't think that this violates the Second Amendment, these laws, even if they're not good policy to your mind.
Yeah, I think it's bad policy, but I don't think that law violates the Second Amendment as defined in Bruen. I think it is reasonable for lower courts to say there's an analogy because there were.
And, this case may end up being have a fairly narrow effect. I think it's one of the first we've seen since Bruen to, challenge this particular federal law, federal prohibition. But it's also one that the court seems to zero in on the specific factors of the individual incident here, which is why I think they went more towards the affray laws rather than the sensitive places laws that you mentioned, which the Supreme Court does talk about in Bruen as well, and notes that yes, there are sensitive places, and I think they even say schools. So, I doubt the Supreme Court would throw out this. Maybe there's some limits to it. This one of the other complaints is that this is like 1,000-foot zone. Some people complain about the zones being too big around the schools, or there's a number of sort of quality of life objections to this. It's
difficult, that one, but the problem is that although I am very sympathetic to the argument that 1,000 feet is too much, you don't want a political system in which courts are saying, yes, there are good analogs for this law, and yes, it's probably constitutional, but we are going to micromanage the exact number of feet. I mean, it's hard to know where the line is. As I say, New York and New Jersey are playing games with Bruen. Yeah. They are clearly overextending sensitive places to entire cities or categories of place that never would fit within the original analogy. And so a court could plausibly go in that case and say, no, you're not allowed to say Manhattan is a sensitive place. But I think once you get down to the granular level of 1,000 feet, having courts say it has to be 900 or 684, it's probably not good when we had legislatures to make that kind of decision.
Right. That's more of a political policy question than a legal question, perhaps. But, interesting case, interesting argument for you. There's something that we don't see the crossover of interstate commerce critique as much in gun spaces, although it presumably affects a lot of other gun laws as well.
A lot of laws. I mean, the seminal example, Stephen, I know we should probably move on, is what happens if you have a gun manufacturer inside a state that sources all the material for a gun and builds it inside the state and then sells it to another person in that state. That is to say, if nothing inside that gun or within the commercial transaction leaves the state. Now, under Wickard v. Filburn, which is a very bad 1942 Supreme Court decision, the court
That's the wheat case I was referencing.
Yeah, the court would probably say, actually, the federal government can regulate that because the mere fact that someone has bought a gun inside that state means they might not buy one from another state, and that affects interstate commerce. Right. I just think that it makes a mockery of our constitutional system. But if you take my view on this, you do, as you suggest, start to implicate a good number of federal gun laws that actually don't regulate what we would classically consider to be interstate commerce. They regulate individual behavior.
Yeah. Yeah. I mean, that's, it's interesting too, because at least when I was coming up through school and through the conservative movement, I guess, that was a big critique. That was a big part of conservative critique of legal theory. And you haven't seen that much with this current court taking on sort of Commerce Clause expansion of this. Like you mentioned in the 90s, you did have some pushback from that court.
In 2005, we had a case, Gonzalez v. Reich, which unfortunately went the wrong way, 5-4. I think now that would go in the favor of the plaintiffs. But since 2005, when it was really that plus Lopez, and then you have to go back to Wickard, the court has largely left this alone.
Yeah. And I don't know, the modern Republican Party doesn't seem as interested in restraining the federal government's power at this point. So I don't know. It'll be interesting to see how this, the conservative legal movement is kind of separated to some degree from the Republican Party, although obviously closely aligned in many ways. But I just recall this being a very big talking point among conservatives and libertarians for a long time, and hasn't really translated to the current court, the Roberts Court. With
it's a tricky area, majority. Right? Because if you start doing what I think the court is obliged to do, and what I suspect, say, Justice Clarence Thomas thinks the court is obliged to do, you end up having to decide whether about 90% of the modern federal government is illegal. Yeah. And I just think John Roberts doesn't want to touch that.
Yeah, that's probably a big part. That's just something I think people ought to take into their calculations when thinking about what will the Supreme Court do on something. The Roberts Court does not often want to blow up like big parts of federal law or precedent. Now, it's not always the case, right? You saw Dobbs. They have done it a number of times, and maybe they're increasingly bold about doing that. But in his tenure as Chief Justice, I think Roberts has wanted to consider the amount of change a ruling will bring upon the country, and whether there's sort of a political will to do that as well, not just legal questions. That's what I see when I look at how the court has done this stuff, especially in guns. The court has really followed late the public opinion on guns in most of these major cases.
And it's done it slowly.
Yeah.
And if you talk about Dobbs, there were a bunch of cases prior to Dobbs. Eventually it became untenable.
And I think
with
Roberts
affirmative
didn't
action.
really want to do. Roberts had a whole concurrence in that where he said we didn't need to overturn Roe to answer Dobbs, right? So
and
he doesn't always win these questions, but
affirmative action is the same. Years of decisions, it was completely unworkable, and eventually they struck that down. Yeah. Whereas with the Commoners Clause, they haven't. They've never really done it. So they'd have to start with what would be a fairly radical position relative to the baseline. And I just think, maybe in my dying years, Stephen, I'll watch it happen slowly.
maybe we'll see. Hopefully a long time from now.
Let's hope so.
Yes. But there is sort of another topic that I think dovetails a bit with this. You mentioned earlier, well, what would happen if somebody, made firearms completely within a state and sold them completely within a state? And there have been some attempts at this. It's sort of ironic in some ways, it's a bit wrongheaded, because it's been not on firearms, but on silencers, right? You've seen some states try to pass laws that effectively attempt to nullify the National Firearms Act regulations on silencers in particular by saying, as long as something is made within the state and sold within the state, it's not subject to the NFA. And that has gone very poorly, I think, in large part because they picked the one gun law where they didn't use interstate commerce as the underlying authority to regulate these items. It's the NFA is a tax, right? It uses the taxing power of the federal government to try and regulate, silencers, short barrel rifles, machine guns, destructive devices, any other weapons. These categories of firearms. And ironically, it's been attacked in the way that you're suggesting from activists who I think they grasp the Commerce Clause objection to many federal gun laws, but they don't grasp that the National Firearms Act is not justified under the Commerce Clause, right?
Yeah, as John Roberts would say, it's a tax rather than a commerce regulation.
And so you've seen people go to be prosecuted for that. I believe it was Kansas tried this at one point. Forgive me if I've gotten the state wrong. I know Texas tried it with a less aggressive approach where they were going to
Missouri too. Although I think Missouri's was mischaracterized because Missouri didn't quite say this law is nullified. What Missouri said was under Prince v. United States, we're not going to help enforce it, which is a slightly different thing.
That's
more of a sanctuary argument.
There was a law. It was a while back where the state law at least gave the impression that people within the state would no longer have to comply with the NFA if the
Right.
if the products were made and sold completely within their state, and that got several people in trouble and charged federally, and they lost, and the state backed away from helping them during their prosecution.
But there are two elements to this, one of which is a tax, the other of which is a regulation. The $200, which is set in the statute, back when Congress actually used to write laws, I think this is a terrible law, but Congress actually used to write laws. It says $200. It's said $200 since 1934.
Right.
It doesn't say the secretary shall decide or according to inflation, which is a good thing for those who want to buy suppressors, because $200 back then was a huge amount of money.
Yeah, it was several $1,000s.
Yeah, it essentially
nearly
was set to
5,000.
double the price of a Tommy gun. That was what they were doing. But you've got that element, which is a tax. And then you've got a part of it, which is not a tax, which is a straightforward regulation, which is the background check. And that background check is a lot more involved than the normal background check system under the Brady Act. So
it has a regulation or a registration requirement, and
that too. That's right.
And a number of other things that you have to do to now they are. We had Knox Williams from the American Suppressor Association on last week. By the way, just to clear this up, because sometimes people will get upset about the use of the term silencer, and I understand why, right? Like it's a bit of a misnomer. It's a marketing term, is really what it is. But that's what that's what Hiram Percy Maxim called them when he invented them. He called his company Silencer Co. That company, I don't think it's the same company continuing. I think he shut his down back in the 30s, but the most popular company today making them is called Silencer Co. A lot of the NFA calls them silencers. I understand that people don't like that it's a misnomer, that they don't fully silence guns like in the movies, and people prefer to call them suppressors, which is fine. But just to clear up why why I'll use that term, and also that's how the vast majority of people know them. That's how what people would know them as, not suppressors or mufflers, even though a muffler is the exact same device, just put on a car, invented by the same guy. In fact, if you go back and read the silencer history is kind of fascinating, because if you go back and read like New York Times archives and reports from like the 20s and 30s when he was inventing this device, he wanted to basically put silencers and mufflers on like everything, including artillery and but also like rooms, full hospital rooms. He attempted to make silencers for that. It's really a fascinating thing. This guy wanted to put silencers on every possible noise-making device in existence, and he succeeded at a number of areas people don't even realize. Car mufflers are just.
We should make one for leaf blowers.
Yeah, yeah, maybe you could. I don't know. But, obviously not all of them panned out. I think the problem with they did try to silence artillery early on. And I think the problem was the silencer would have to be so big,
right,
that you couldn't like move around the artillery with it.
Also adds a bunch of complexity you probably don't want in the middle of a battle.
Yeah. So anyway, sorry to get off on a tangent here, but this comes up because the Senate now, after the House already passed a provision that would both cut the tax, eliminate the tax on silencers under the NFA, but also delist them entirely from the purview of the NFA. The Senate came through and now has actually doubled down on this and expanded it to not just be silencers, but also short barrel rifles and shotguns, and what the NFA calls any other weapon, which is a confusing term certainly, but basically applies to like disguised guns, like an umbrella gun or a cane gun. That would be any other weapon under the NFA. And so the Senate and the language, the House language kind of was demarcated the tax elimination from the delisting, so that, in theory, if you strip one out, the other one would still work. The Senate language doesn't do that. It just removes these things from the NFA altogether, thus, in practice, eliminating the tax because you're not subject to the NFA anymore, but presumably making it a little bit more vulnerable to what may be coming here, which is the parliamentarian is going to decide whether or not this is actually a budgetary issue, as you described a moment ago. The problem comes in whether or not eliminating the registration requirements and the other regulations surrounding being listed in the NFA is going to comport with the reconciliation rules, with the Byrd Rule, right? And so it sounds like you're skeptical of that. What do you think?
Well, first, I would say that I think the NFA is a really bad law, and a lot of it is just completely random. If you look at what's in there, it almost feels as if, with the exception of automatic weapons, which I think probably would be unpopular if declassified today, there's not much in there that anyone ever really freaks out about. And, short-barreled rifles, certain shotguns and suppressors, it's silly. And this was because in 1934, Congress wasn't really sure what it was trying to do. There were a lot of conservative Southern Democrats who were more attached to the Second Amendment than many of the Northeasterners within that huge coalition. And they started off going for essentially all handguns and realized they didn't have the votes. And so they put in a bunch of other stuff.
From the National Rifle Association, actually.
Correct. But they put in a bunch of weird stuff, and it's just, and I think it was very much tailored to fear of, at that point, the mafia in Chicago. Like, what guns do they use? We'll ban them. And they just couldn't add in your handguns. But the law has nevertheless persisted, as our friend Elizabeth Warren would say, and it's on the books with the same $200 fee as obtained at the time. So if Congress were to pass a law, either just removing the items you mentioned from this or repealing the whole thing, I would be entirely in favor of it. So what I'm about to say has nothing to do with my preferences politically. The problem here is that the bill that is currently under consideration is going to have to pass on party lines or close to it. And that means that it is not going to get 60 votes in the Senate, because at present there are not 60 Republican senators. And because of that, it is going to be passed via the reconciliation rules that are, by definition, related to the budget. There is a term that is used in the Senate called the Byrd bath. This is because the reconciliation rules are also known as the Byrd Rules, named after the West Virginia Senator, Robert Byrd. And the Senate, as such, has to make sure that what goes into a reconciliation bill is only budgetary, or at least is reasonably connected to the budget. The House doesn't have to worry about this at all. The House is a purely majoritarian institution. You can do literally anything in the House if you have +1 vote over the 50-50 line. The Senate, that's not the case. And so removing anything from the NFA is fine if by that you mean getting rid of the tax. But if you're making structural changes to gun laws or gun regulations or how the background check system works, the question becomes, is that budgetary in nature? Now, I imagine the argument that will be made in the Senate is, this is a budgetary question because the NFA is primarily interested in the raising of revenue with its tax.
Right.
But I think the parliamentarian's going to say, no, the $200 tax can be zeroed out, as, say, the Obamacare mandate penalty was zeroed out in reconciliation. But you can't make material changes to the law elsewhere. And then the Senate will have a decision to make. Does the Senate want to overrule the parliamentarian, which it can? Or does it even want to abolish the filibuster, which is a 60-vote threshold? I think it will be a very bad idea in general, but also for my political aims, for the Senate to overrule the parliamentarian, because the Democrats will then do that in 10 minutes next time they're in power, maybe on something we don't like, say an assault weapons ban. And abolishing the filibuster would make it very easy, with a bare majority of votes, to pass all manner of federal gun control and wipe out huge numbers of gains at the state level. So although I am very much in favor of the Hearing Protection Act or repealing the NFI entirely or ripping a lot of it up, I do think here that we may end up with a situation in which the parliamentarian says you're not allowed to do that. So what they'll do is they'll zero out the tax. So if you want to buy a suppressor or a short-barreled rifle, you can do that, but you're going to have to go through the long federal background check and you're going to have to register it. That's my guess, but who knows?
Yeah. And look, that I think from all of the sources I've spoken to on the Hill on this, I think that is the common view of what is most likely to happen. It's not a guaranteed. Certainly the gun rights groups are all on the same page on this, and they all are confident. We just had Knox Williams from American Suppressor Association, as I mentioned earlier on the show last week. He was very confident in the argument. As you summarized it, essentially the NFA is a tax. Courts have ruled it's a tax, including the Supreme Court. And so, changing the definitions in it, which is essentially what this law does, it just changes the definition of firearm under the NFA to remove silencers, short barrel rifles, and shotguns, and any other weapon. It leaves in machine guns and destructive devices, which are basically like explosives. But, it just removes them from the definition. So these things are no longer regulated by the NFA, although it would, to be clear, it would leave them regulated by the Gun Control Act, which is not affected by this law. Silencers are also included in the Gun Control Act. You'd still need a background check to buy a silencer from a federally licensed dealer,
right?
A commercial sale. Just to be clear about what it actually, the effect it would have. But and so their argument is the registration process. All that's there to do is to show that you've paid the tax. So getting rid of that aspect of it is budgetary. But I don't know.
But the background check element is the sticking point, I think, because how can you say that's part of the tax? The registration argument, I actually think is quite clever. It's almost the equivalent of saying you have to file your taxes every year and pay them. Right. But you don't do a federal background check when you file your taxes. I hope I'm wrong. I wouldn't be upset if the Senate parliamentarian said, no, this whole thing was designed as a revenue mechanism. I just don't think it's going to happen.
Yeah, I guess the argument of the background check is just that it's effectively the same background check that you do anyway through the gun control. You're just doing a NICS check, essentially. That's at least what that was his argument last week.
That's fair.
So I don't know. We'll see what the parliamentarian says. Everything I've heard, and this was one of the big sticking points, the reason that delisting wasn't included initially in the House bill after the Ways and Means Committee put out their text, is that they thought the parliamentarian would not accept this. I think, if you listen to the podcast, we get to a point where Knox also is just like, we might as well try, is sort of the attitude I think you hear a lot. Maybe the parliamentarian does strip it out. If that happens, with this text, you wouldn't get the tax cut, but he said they can offer an amendment that's just the tax cut. And so I think there's some political risk to doing that. Because you have to count on the Republicans to follow through on doing an amendment after this gets stripped out, if it does get stripped out. But that is a solution potentially where you still get the tax cut at least, which I think I haven't come across anyone, even in the gun control groups, who think the tax zeroing out is going to be stripped or would be tossed out by the parliamentarian. So
I think he's right, by the way, that it's a good thing to try. Sometimes when people say that, I don't agree. For example, if somebody knows that something is unconstitutional and they try it anyway, I think they should be impeached. We've seen a lot of this recently. But what we're talking about here is the Senate interpreting Senate rules and then subjecting those rules to the Senate's chosen arbiter, the parliamentarian. There's nothing wrong there with trying. The problem would come afterwards. If you ended up in a situation in which the Senate was just ignoring its own rules all the time, then I would have a problem with it. But of course they should try.
Yeah, and I think strategically you got to earlier you mentioned sort of the reason why this is worth trying, at least because right now, even if you probably could get a couple of Democratic senators to come across on at least the Hearing Protection Act, the silencer version of this, but you're not going to get 7, which is what you'd need. And same thing in the House. It would be a pretty close vote in the House, probably, because you're not going to even get all Republicans in the House at this point. Fitzpatrick probably, he's on record not supporting it. But you could maybe still get it through. But it's just, attaching it to a larger must-pass bill is the way that you're going to have a chance of getting this through. And so strategically, it makes sense. It's just a question of, whether or not it's going to comply with these rules, which are there because senators give up their right to object on these budget bills, right? That's the whole idea of reconciliation, is we're giving up some of our rights of how we do things in normal business so that we can get budget bills through. But in exchange, there's strict rules about what can actually go in these bills. So
correct.
It's there for a reason. And yes, it can quickly devolve, if you mess with the rules too much, as you mentioned. And so I honestly, yes, you could so-called blow up or nuke the parliamentarian over this if she says no, but I would be very surprised if there was appetite to do that over this. Right. If that's going to happen.
It would be short-sighted.
Yeah, it would be very short-sighted, but also like something like nuking the filibuster or nuking the parliamentarian. That would happen. The circumstances for that to happen would have to be something, I think, a much higher priority on the Republicans' list than delisting silencers and short barrel rifles from the NFA. You know what I mean? Like, it's just not a realistic. Right. And if you were going to do that, like, you'd want a much bigger reward than just delisting from the NFA a couple of categories of guns and accessories, right? So that's a huge. That's something that's why they call it nuking, because it's a very big deal, and we've seen it happen a couple of times with some of these judge appointments, and it's that.
Well, it didn't work out, did it, for the party that did it? I mean, the Democrats did that back in 2013 because they were fed up with Republicans obstructing their justices, or I should say judges.
Judges, yeah.
And now they have a 6-3 Supreme Court.
Right.
It upsets them every summer and October. So, it's a cautionary tale.
And now, as a country too, like I guess this goes back to, sort of conservative principles. If you're conservative, another thing beyond just wanting the Republican Party, the party that more closely aligns with your political objectives, to win, you also kind of, like, at least in my estimation of the movement and its underlying principles, there's a sort of there's a natural inclination towards trying to not radically shift the status quo, right? Constantly. That's one of the problems. You look at European parliaments that you have, is that they can pass things often on straight party lines and radically change the laws of the country, and that can happen every time there's an election. At least one of the arguments is that it lowers the trust in government as an institution over time, because you're just constantly shifting what the laws are in big, significant ways. And so that's another aspect of the way the Senate's designed, and the way it's operated for the last century plus, is to be sort of a cooling off body. Correct. You're not just meant to be the House again. Right. Yes. That's not what it's supposed to be. So I don't know. There's something to be said about that as well. And the fact now that all of our judges can just be appointed on party lines, how does that impact things, 50, 100 years from now, when every judge is viewed as extremely partisan, because that's what they are, right? That's the system we've ended up with. Yes. Anyway, it's a little outside of our purview maybe here at the Reload, but just another thought I had on it. One last bit on this Senate bill. So there's another sort of power of the federal government question that comes in this. The Senate, so there's an issue of state mirror laws. There's a lot of states have what are effectively NFA mirror laws, where they say you can't own these NFA items unless you have like the tax stamp, or they might call it different things. I think Colorado calls it a license from the federal government, which they appear to be referring to the tax stamp or the registration as what you need in order to legally possess those items in Colorado, right? And a number of states have these laws, and it's been one of the problems that people have pointed to. Senator Lummis from Wyoming, a Republican, has expressed concerns about that aspect of delisting. Now, activists who've written these laws have thought of this before, right? There's a section in the HPA and Short Act, which has now been included in the Senate bill, that says effectively, it basically tries to nullify these state laws. It says, in the case of any registration or licensing requirements under state or local law with respect to Now, the way they've written it doesn't include silencers, which ASA has said there's supposedly going to be a fix for this, but with respect to short barrel rifle, short barrel shotgun, any other weapon, which is determined by reference to the National Firearms Act. So they're talking about state laws that reference the NFA. Any person who acquires or possesses such a rifle, shotgun, or other weapon in accordance with Chapter 44 of Title 18 U.S. Code shall be treated as meeting any registration or licensing requirement with respect to that firearm. So they're basically saying, like, these state laws, the state mirror laws, they're trying to nullify them through federal language, through federal legislation.
Right.
What do you think?
So just to be
of that?
clear, so the argument here is this. Suppose that Florida, where I live, had a law that said that you're allowed to have a short-barreled rifle in Florida under Florida law, providing that you have been through the federal process, and then that federal process gets taken away.
Yes.
This bill is saying that for the purposes of state law in Florida, you are good to go.
Right.
Because the licensing requirement no longer exists. Is that correct?
That's essentially what they're saying, yes.
Well, I'm not an expert in this. This is a relationship question that I'm unsure about, but instinctively, I can't see how the federal government has the capacity to define state law in that manner. It would seem to me that would be a Colorado problem. You mentioned Colorado.
Right.
If people are no longer able to go through the licensing process that is a prerequisite to be in compliance with Colorado law. Now, I do think that a court at the state level would be likely to side with any plaintiff who was prosecuted because he wasn't in compliance with a federal process that didn't exist.
Yeah, good point.
So as commentary, I think the Congress's heart's probably in the right place. But whether or not that preemption is allowed, I'd have to look into. That is an odd one.
It is odd, right? That's what I thought as well. I mean, it's not new, right? This is something that's been in the HPA before, the Hearing Protection Act, and these other bills that try to delist items from the NFA, because activists are aware of this problem.
Yeah.
Right? And I did ask, like I said, Knox about it last week, and he also, they sort of quibble about the language of some of these state laws and whether it would really become illegal to own these devices if they were no longer listed on the NFA. But I don't know, if you read some of these state laws, especially the Colorado one, it does seem to imply that if you don't have that federal registration or the tax stamp, then you can't possess these things in Colorado. Like that's how the law is written. It says these things are illegal unless you have this. Yeah. And so if you no longer can get that, the logic of the law would suggest that they're illegal. But you're right. I mean, it does raise a number of interesting questions. Like, certainly, if you can't get that, if it's impossible to get at the federal level, can you still be prosecuted at the state level? I mean, it feels like a state level problem to me.
It does. Now, if the language were essentially clearing up any potential federal criminal or civil liability, I think it would be a good thing to put it in there. In other words, saying, look, there could never be a federal component to any prosecution. But you're not suggesting it says that. The state level courts, again, I think would smile on the plaintiffs. I mean, imagine, and this is a reductio ad absurdum, but imagine for the sake of argument that tomorrow the state of Florida says you are no longer allowed to own a rifle unless you have a permission slip from Mars. All right. There is obviously no court in the world that is going to uphold a conviction on that basis. Now, that isn't what's happened here, because if this does go through, the rules under the National Firearms Act will have been in force for 90 years? Yeah. So a court's not going to treat it quite as preposterously as my silly example, but still, you can't pass laws that require people to do things that are impossible. So But I'm with you, Stephen. Instinctively, I think that's a state question. I can't see how the federal government could preempt it.
It is an interesting one. Like it does. One, I wonder how you could enforce these state laws if it's impossible for people to get these federal, requirements to begin with, like through no fault of their own, especially if they already had them, right? That's another problem. If you live in Colorado, it's not illegal to own suppressors or silencers or short barrel shotguns or whatever. It's only illegal if you don't have the federal tax stamp to do it, which would be illegal under federal law as well.
Right, but it gives Colorado the capacity to prosecute you as well, which I imagine it wants.
And this is common in gun laws. You'll see a lot of mirror laws in at the state level that just sort of repeat what the federal law is so that they can charge you if you do the same thing.
I hate those, by the way. I think it's really good that, I'm pretty sure I'm right about Florida, that Florida's view on this is we don't care what you have, but you have to follow federal law. I like that. I don't see any particular reason to mirror it. Now, if a state had strong views on it and then the federal government got rid of its requirements, I would understand a state saying we're going to pass an equivalent law at the state level. But
sure. And there are some states that just outright ban NFA items altogether under state law and don't have that exception for if you have the federal tax stamp. So those states do exist. They're the deeper blue states, as you could imagine, California and New York, places like that. But there are these, but the NFA mirror laws are much more common, and they are different in exactly how they're worded. And Knox was less concerned about these causing problems for people, and I do think like it would be pretty audacious for Colorado to go around and prosecute people who previously had tax stamps but don't have them anymore because the federal government got rid of the requirement. It would never hold up. Pretty wild.
It would just never hold up unless they pass their own system and say you have to be in compliance with it. That would never hold up.
Which is a potential political fallout of this. You might get some more of these states that have moved bluer over the years to, get more restrictive around these items. If the federal government gets less restrictive, that could be an outcome. But I just thought it was an interesting thing because it's basically the federal government saying, these state laws that you have that are contingent on, this federal process, we're getting rid of the federal process. So these state laws they don't matter anymore, or they're fulfilled by default according to our decree. And I just wonder if that works.
I may be missing something, but I'm with you. That sounds very odd to me.
Well, anyway, so it may be more of they may have more work to do at the state level to fix those issues, even if this federal language gets excluded. But maybe including it symbolically could help convince state legislatures. I don't know. We'll have to see, because first thing is to get through this parliamentarian hurdle, which I think, for the reasons you laid out, is going to be the hardest test of this current Senate language we've seen on this issue. But we're going to stay on top of that for sure and continue reporting on it and let everyone know which way it goes. And we'll have to have you back on the show maybe down the line when we have some answers on that front. But appreciate you coming on and giving your insight and giving your view on things. And it's always good to have you on the show. For people who don't know, can you tell them where they can follow your writing?
Sure. Well, you can find me at National Review. You can find me in America's First Freedom. And you can find me on Twitter. I guess it's called X now. I just can't bring myself to call it that. At Charles C.W. Cooke. That's Cooke with an E. Absolutely. All right. Well, appreciate you doing this, and we'll see you again real soon.